Hi, welcome back everyone to this session. And in this session, we are going to discuss about public international law and why was there a necessity for a public international law and its evolution. So, discussing about why there was a need for public international law. So, in the modern state, we know that by globalization, by the innovation of technologies, the world has come closer. By the transportation means, what the acts we do does not constrain itself to one nation or one state. It is spread over multiple nations or multiple territories, and there comes, if we have to regulate these actions, there need to be an understanding between the states and how the states shall deal with each case, whether if it's to be whether if it's by public international law, if it is to be dealt by private international law, and so on. So there arises a need for public international law, and then we can see scenarios where the states, for trade and other purpose, they used to send the diplomats to each other states, and they still do that. So from ancient times there was a necessity for public international law, that is to avoid unjust wars or put an end, come to an agreement for treaties, etc. And then, with respect to the evolution of the public international law, the 17th and 18th centuries witnessed the final evolution of the concept of the modern state system in Europe. And we know that Hugo Grotius is termed as the father of public international law, or father of international law, and he did not say anything about international law, but in his book, The Law of War and Seas, he explained some of the basic characters or basic principles that the states shall abide by in their intercourse with each other, and these are also the basis of the modern public international law principles. So that is why we consider Hugo Grotius as the father of international law, but the term international law as such was coined by Jeremy Bentham, that is in 1780. Hugo Grotius published his book in 1625, and later Jeremy Bentham coined the term international law in 1780s. And so the 17th and the 18th century witnessed the final evolution of the concept of modern state system or the present international law systems. Now, this process was greatly influenced by the Treaty of Westphalia in 1641, making the end of the 30 years of war. And in 19th century, it witnessed the rise of powerful new state, the expansion of European civilization overseas, the modernization of the world's transport, and the greater destructiveness of the modern warfare. These developments made it necessary for the society of states to acquire a system of rules which would regulate the conduct of international affairs. Now, remarkable developments were made in the law of war and neutrality. A spirit of adjudication by international arbitral tribunals was created, and such tribunals started following the Alabama Claims Award of 1872. Alabama Claims Award of 1872, which in turn provided important new sources of rules and principles. The Geneva Convention of 1864, the Geneva Convention of 1864, and the Hague Conference of 1899. So, Geneva Convention of 1864 and Hague Conference of 1899 are also landmarks in the development of international law. So, we have to see that the spirit of adjudication by international arbitral tribunals, and that started following what Alabama Claims Award of 1872, and then we have the Geneva Convention of 1864 and Hague Conference of 1899 that also became the landmarks in the development of international law. Then the 20th century witnessed major developments again. So this developments added new scope or new dimensions to the concept of international law. The Permanent Court of Arbitration was established by Hague Conference of 1899 and 1907. That is the Permanent Court of Arbitration that was established by the Hague Conference of 1899 and 1907. Then the Treaty of Versailles after the First World War laid down the foundation of the League of Nations for maintenance of peace and security among nations. So this was one of the first steps where the nations came forward, realizing the need for a combined effort to maintain peace. So this was one of the first steps taken by the nations. That is after the Treaty of Versailles after the First World War laid the foundation of the League of Nations, and that was for maintenance of peace and security among nations. Now, the Permanent Court of International Justice. The Permanent Court of International Justice was established in 1921 as an authoritative international judicial tribunal. After the Second World War, the United Nations was established in 1945. So, presently we have the international body United Nations, which governs over almost all the international community and relations. So that came into existence only in 1945, and before that we had the League of Nations with a similar attempt. So it attempts in regulating the dealings of civilized states with one another. The present International Court of Justice. So earlier we discussed about Permanent Court of Justice and the present International Court of Justice known as ICJ, that was established in 1946. So UN came into being in 1945, and in 1946 ICJ was established. Various agencies under the UNO such as ILO, that is International Labour Organization, ICAO, the WHO, World Health Organization, then UNESCO with respect to education and culture, and came into being. So we have several international bodies under UNO. The UN conferences on the law of the sea, diplomatic relations, and the law of treaties were other important developments in this century. So all these combinedly gave its contribution to the development of the international law, and here we are specifically referring to the public international law. So that is with the necessity and evolution of the public international law, and we have several definitions. We did a session on definitions separately. Once again, the most important definitions of public international law we refer to here is Oppenheim. Then we discussed about the criticism of Oppenheim's definition, because Oppenheim discussed only about the relation and intercourse between the states of the civilized states. It did not include about the individuals or international organizations. That was the criticism there. And then we have Lord Coleridge definition of international law in the case law of Quinn versus Kane, where Lord Coleridge defines international law as the law of nations is that collection of usages which civilized states have agreed to observe in their dealings with another. So what Lord Coleridge said was that it is a collection of usages, and it is followed by whom? The civilized states to in their dealings with one another. And then we have Ariely, who defined international law as the law of nations, or international law may be defined as the body of rules and principles of action which are binding upon civilized state in their relations with one another. So all these definitions refer to interaction between the civilized states. Now, West Rand Central Gold Mining Company Limited versus King. So this is a case law. In this case, it was defined as international law was defined in this case as the form of rules accepted by civilized states as determining their conduct towards each other and towards each other's subject. Then we have Torsten Gill. According to Torsten Gill, the term international law means the body of rules of law which apply within the international community of society of states. So till this definition, what we looked was everyone defined international law as a code of conduct or rules followed by the nations for their interaction between or among the civilized state. So in the definition of Torsten Gill, it was referred to as the rule of law which apply within the international community of society of states. So this is the first definition we came across, which did not directly refer to civilized state, instead referred to the international community of society of states, and that was defined by Torsten Gill. Now Hackworth views international law as a body of rules governing the relations between the states. Yet again the same. Now Philip C. Jessup has defined international law as law applicable to states in their mutual relations with the states. Now Gray. According to Gray, international law is the body of rules which regulate the conduct of states in their intercourse with each other. Then we have Kelsen has given a definition similar to the one given by Gray. That is, it is again regulate the conduct of states in their intercourse with each other. Then we have Hall. In Hall's view, international law consists of certain rules of conduct which modern civilized states regard as binding on them in their relations with one another, with a force comparable in nature and degree to the binding the conscientious person to obey the laws of his country, which they also regard as being enforceable by appropriate means in the case of infringement. So when it comes to the definition of whole, here it is said that it is regarded as binding. So it is not said as binding, but regarded as binding, yet again between civilized states, that is modern civilized states. And here what else is said, and it is comparable in nature and degree to that binding. The law has some kind of enforceability. So in Hall's definition, they also regard the international law as being enforceable by appropriate means in case of infringement. So far in all the definitions we discussed about interaction or intercourse between the civilized states, but none discussed about the enforceability. So it was in the definition of Hall that discussed about the regard as binding and also regard as being enforceable by appropriate means in case of infringement. As well, in the definition by Torsten Gill also referred to international community of society of states instead of civilized states. Now Charles G. Fenwick has defined international law as the body of general principles and specific rules which are binding upon the members of the international community in their mutual relation. So Charles G. Fenwick, he also referred to the subject as international community rather than civilized states. Now the most accepted modern definition of public international law comes from J.G. Stark. J.J. Stark has given a comprehensive definition of international law reflecting its present position. His definition is as follows, that is, international law may be defined as the body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound and therefore do commonly observe in their relation with each other, and which also include the rules of law relating to the functioning of international institutions or organizations, their relation with states and individuals, and certain rules of law relating to individuals and non-state entities so far as the rights or duties of such individuals and non-state entities are the concern of the international community. So the definition by J.J. Stark is pretty wide and it is pretty comprehensive, including multiple aspects. So let's just break down the definition here. So international law may be defined as a body of law. So as with all the definition, it is a body of law. And what is it composed of? So here J.J. Stark says that the greater part of this international law is composed of principles and rules of conduct. So it has principles and rules of conduct, and that is yet again the same as the previous definitions by all the jurists. Then here also the principles and rules of conduct and who has to abide by it, and the states feel themselves bound. So it is not said that it is binding, but it is said that the states feel themselves bound, and therefore what do? They commonly observe. So themselves bound plus they commonly observe, and for what? In relations with each other. So yet again, till here the definition is very similar to the previous definitions. That is, there is a sense of binding or regarded as binding, and thus they commonly observe it. It is a body of law, and it governs principles and rules of conduct between the states. So till here the definition is more or less the same as the previous definition, but J.J. Stark has added two more aspects to this definition. The first aspect is that he continues by saying which also include, and the first aspect, that is A, the rule of law relating to the functioning of the international institution or organization. So he said that this international law shall also include the functioning of the rules relating to the functioning of international institution and or organization with their relation with the states and individuals. So he included international institutions and organizations and their relation with states as well as individuals. No one discussed about individuals before. Here states as well as individuals. And the second aspect, B, is that it also includes certain rules of law relating to individuals and non-state entities. Like it also includes individuals and non-state entities so far as the rights or duties of such individuals and non-state entities are the concern of the international community. So if there is an issue between any individuals or non-state entities, if their rights and duties concern the international community, then that is also brought under international law. So that is the most appropriate definition in the modern era. That is J.G. Stark's definition of public international law. He said that international law is a body of law, and it is the greater part of it is the principles and rules of conduct which states feel themselves bound, and therefore they do commonly observe, and that is for in their relation with each other. And it shall also include 1, the rules of law relating to the functioning of international institutions or organization, their relation with the states and individuals, and second, certain rules of law relating to the individuals and non-state entities so far as the rights or duties of such individuals or non-state entities are the concern of the international community. So that is with an introduction, the necessity, evolution and the important definitions of public international law.